Hi guys! I feel like I forgot how to stream, so this might be a little bit of a struggle session. It's been like 2 weeks since I've popped up or done any videos. I miss you guys so much, it feels really weird. This morning, as you know how things go with me, I checking in on are there any good appeal decisions? What's going on out there in the post-conviction world? Came across this story from New York. So we're going to be traveling over to New York today. I think we're in the Brooklyn area. We've got a New York man convicted based on his rap lyrics. Getting his conviction reversed, he's getting a new trial. We are going to be looking at the full decision. So I've linked that in the chat and it's also in the description. It's 11 pages long. But when I started reading it, right in the beginning, the decision, there's a line that says that the court told the state, the prosecution, that they better go find a gang expert to put on the stand. And the state was like, well, we don't have any witnesses ready. And the court's like, well, you have 10 minutes. So they go grab a guy and they put him on the stand. And I guess we're going to find out his testimony about lyrics and his knowledge of gangs, rejected by this court. So I thought you guys would like that. It made me stop what I was doing and schedule this live stream. So it's going to be really good to see everybody in here. Mr. Big Play Bray's in the building. Good to see you. We've got Eric, Ian, the whole gang. Hey, it's Luis. Hey. Speaking of Luis, always hang out with Luis over on Dolly Talk. I have Dolly's channel linked in the description. He's covering the James James Ogletree trial. It's like a murder in prison trial. And he's going to be starting that at 5 Eastern today. So if you guys are looking for some cases to go and follow and check out, thinking of Dolly because Luis is in here, but that's linked in the description and maybe we'll redirect over to Dolly if he's live when we're done with this. Who else we got in the building? We've got 7,000 tabs. Love Nona, good to see you. Nem is here, says hello, gang. This is not Georgia, guys. This is not YSL. We are over in New York today. Tyranny for you, tyranny for everybody, says good morning from Amsterdam. You gotta throw it across the ocean to us. Skillet Pan, good to see you. Recommending here the Key and Peele skit. Love them. With the rap lyrics, Rapper Confession. I think that sums up the experts. Definitely gonna do that. I don't know if I've seen that one, but there's so many. I like the name pronunciation skit that Key and Peele do. I feel like that every time I read a name on stream. So lots of love for their skits. Let's see. Trade Keisha in the building. Marlena Mack. Good to see everybody. FFS. We've got Aaron. I'm going to take a segue. I have this preloaded, you guys. And we're going to get into it, I promise. Give me like 2 minutes. I haven't streamed in like 2 weeks, but I've been collecting things I got in the mail that I want to open up. And this is actually a struggle to open. This is actually something that like a month and a half ago, I'd seen Aaron post this picture. Hopefully this is the right thing, right? It's not going to be a misorder. Or I'm going to say that we're opening Trial by Lies, the Lamont McIntyre story. It's the right thing. Good job, postal people. And when I saw Erin post this, I was like, oh gosh, here we go. Not only do I want to support my girl Erin, that's Adventure Erin in the chat, but if she's talking about a story, and this is a case that she helped work with, I'm like, there's going to be some mess. There's going to be some mess. So this is going to be my weekend reading. I'm going to drop a link in the chat to you guys if you want to check this story out. Here's a preview. Here's a preview. After 8 years of investigation, the tragedy ran even deeper. Detective Roger Golubsky, and when I shared this, you guys were like, some of you knew that name and knew that there's more mess than just the Lamont McIntyre story that the same detective has been involved in. But this preview in relation to Lamont's case. So, with the Kansas City Police Department, notorious for his sexual abuse of women in the community, this is the detective. This is about the detective. Had previously harassed and abused Lamont's mother, causing her to move to get away from him. After her rebuffs, the detective created a 5-person lineup, which isn't even the number of people you're supposed to use for a proper lineup procedure. They put Lamont and 2 of Lamont's family members in the 5-person lineup. So you have, just off a pure guess, if you feel inclined, human psychology will tell you, if you put 5 things in front of me and you make me feel like I'm supposed to choose one, I'm more likely to choose one because that's what I think I'm supposed to do. Even if none of the 5 might be the right answer. It takes some thinking outside the box to consider, hey, I don't think any of these are the right answer, and then to think you have the option to not choose at all. And if we're not doing this lineup procedure by the books, do you think the person orchestrating and administering the lineup is going to sit there and say, you know what, if you don't think any of these people are the person, don't choose one? But in any case, this lineup was set. You have a 3 in 5 shot to pick somebody that's a family member of this woman who was rebuffing the advances of a detective that is now known for his sexual abuse of women in the community. So I will be checking this out. You can go to trialbylies.com. Aaron, thank you so much for sharing this. And, sorry I'm getting to it like a year later. Let's see. I think I have to put HTTPS. That link is in the chat for you guys. So very excited to hear more about Lamont's story. I feel like Roger Golubsky should be the one when we're talking about convictions. Maybe we have the roles switched here. Factual Lie, good to see you. Been good to see you in other chats for the last few weeks. David, good to see you. Leo, we've got Love Silky hanging out over on X. Hey, let's see. We got Felicia. Hold on, grab a guy. I don't know, Aaron. Chad Diggy, what's up? Good to see you. FFS, did they just pick a random dude to be an expert? I don't know, but you guys, just go stand outside this courtroom. This is somewhere in Kings County, New York. Go stand out in the courtroom in the hallway and just see. If you want to be a gang expert, if you want to get on the stand and testify about what lyrics mean, maybe just go stand and be at the ready. Pull a Michael Sprinkle and put your face at the door. So the next time the prosecution doesn't have a witness ready, you could be the one chosen. Oh, man. Bookishly Bohemian says, like the live, y'all. Thanks for the reminder. Sirach, we've got a ton of people here. So hey to everybody. We're going to roll into this story. We're going to get right to the filing because the summary is cool. But the filing, sometimes there's one-liners that the summaries don't pick up on. We're going to read it all. Let me open this. Make it big. I think it works better when I move myself to the top corner. So we'll go up here. All right, so there were oral arguments for this on June 6th. And again, so guys, in New York, their court system, I don't know if they just want to be fancy or if they have so many moving parts that they just said whatever. But when we say Supreme Court of the state of New York, that is not the highest court in the land. We're in an appellate division. We're in a second judicial department. It's really weird over there. It's very confusing, the hierarchy of courts in New York. But we are over in Kings County. So that's what we're going to know. This is the case of the People versus Idrissa Reaves being appealed by the trial defendant. So let's see. By the defendant from a judgment of the Supreme Court. Now, pay attention to this name. This is the trial court judge, Vincent Del Giudice, rendered on June 13th, 2019. So we're 6 years out from that, and entered in Kings County, convicting him of criminal facilitation in the second degree upon a jury verdict and imposing sentence. So we've got all of the attorneys here. So this is for Reaves. We have Patricia Pasner, maybe it's Patzner. And then arguing for the state, we have Eric Gonzalez, District Attorney, Brooklyn, New York. And then let's see. Got Justice here writing, on this appeal, we are asked to determine whether the Supreme Court erred in admitting into evidence a rap song which the defendant had performed over a recorded telephone call during his pretrial incarceration. So again, Supreme Court erred. This is going to be, I'm blocking it. My moving to the corner was a bad idea. So this is the trial court, right? We are speaking of the trial court. When we see these references here, did the trial court err? I mean, did the Supreme Court err? We're speaking about the trial court. So Judge Whitaker and YSL, that was the trial court. We're used to thinking of Supreme Court in terms of appeals. But here in New York, because they do what they do, this is the trial court. So they're here to determine whether the trial court erred in admitting into evidence a rap song, which the defendant had performed over a recorded telephone call during his pretrial incarceration. So he's incarcerated. What I'm getting from this first line, he's being held in custody before his trial, but he's already been arrested. Hopefully he's already been indicted, right? He's not just being held without an indictment, but who knows? Does something while he's being held awaiting for trial. And this is what they're going to bring in that's going to be at issue for the purpose of this appeal. They bring it in through the testimony of an investigator employed by the Kings County District Attorney's Office, whom the court qualified as an expert in slang. So their gang expert is coming from with inside the building. He's an investigator with the same district attorney's office trying the case. For the reasons that follow, we conclude that under the facts and circumstances of this case, the investigator was unqualified to offer expert opinion testimony regarding the meaning of rap lyrics. Additionally, while the investigator's initial interpretations of the lyrics were often varied and reflected the lyrics' inherent ambiguity, the investigator's ultimate proffered opinions precisely and remarkably mirrored September 24th, 2025. Well, that's just the date on the page. This is great writing. Let's read this again. The investigator's ultimate proffered opinions precisely and remarkably mirrored the people's exact factual theory of the case. This is a strong call out. This is not, neutral language. It might not sound like the way that we might talk here in the chat, like they're cooking, let's fire it up. But in an appeals decision, for a justice to write, this gang expert who's also an investigator that works with the prosecution, their opinions delivered through their testimony precisely and remarkably mirror the state's exact theory. Isn't that funny? That's what this line is saying. So this is spicy. Moreover, the investigator's interpretations of the lyrics also implied that the defendant had committed prior bad acts and crimes that were not charged in the indictment. So we have some 404B evidence issues here. The investigator's just going off the wall, like interpreting lyrics, and then in his interpretation of lyrics, introducing possible bad character and prior bad acts evidence through his opinion testimony that oddly, precisely, and remarkably mirrors the state's theory of the case. Accordingly, we find that the defendant was deprived of a fair trial by the admission of this evidence, and therefore the judgment convicting the defendant of criminal facilitation in the second degree must be reversed and a new trial ordered. So let's get into the details. We're going to get into the details here with this factual background. This spacing is kind of weird. It bleeds right into bleeds from the previous section, like a hanging sentence. The defendant was charged with, among other crimes, murder in the second degree under an acting in concert theory, and criminal facilitation in the second degree, an element of which is that the defendant believed it probable that he was rendering aid to a person who intended to commit a Class A felony, in this case, murder. And our footnote here is citing the statute, so 115.05. A person is guilty of criminal facilitation in the second degree when believing it probable that he or she is rendering aid to a person who intends to commit a Class A felony, he or she engages in conduct which provides such a person with means or opportunity for the commission thereof, and which in fact aids such person to commit such a felony. All right, so he's being charged with not maybe being the person to pull this trigger in this murder, but aiding somebody who did, acting in the facilitation of the person that did. Let's see. The charges stem from the shooting death of Nashawn Henry, which occurred on August 29th, 2016 in Brooklyn. So the trial was about 3 years after the incident. According to the people's evidence, the shooter opened fire into the victim's van while another individual, the driver of a gray Nissan, made a U-turn, stopped, opened the passenger door, and waited for the shooter to get into the vehicle before driving away together. Authorities later discovered that on the day in question, the gray Nissan was being operated by the defendant, and that prior to the shooting, the defendant's vehicle had followed the victim through various neighborhoods in Brooklyn. The shooter was never identified or apprehended. Oh. So now we're going to talk about a hearing that happened pre-trial. While the defendant was incarcerated at Rikers Island and awaiting trial, he, with the assistance of another person, authored a rap song, which the defendant performed over recorded telephone calls. I don't know, this is like the culmination of everything, right? We've got an investigator from the prosecution team that's going to be a gang expert that was waiting at the door like Michael Sprinkle to be thrown on the stand on a whim, right? You don't have your next witness ready? Just go get someone. And our Sprinkle version number 2 comes running through the door, jumps on the stand, and is going to not only tell us what lyrics associated with the defendant mean, but it's going to be gathered from a jail call that was recorded after the defendant was taken into custody. This is the potpourri. This is like the bingo card being maxed out. So the people sought to admit these recorded telephone calls, including the rap song, into evidence at trial. After playing the rap song for the Supreme Court, the trial court, prior to the start of the defendant's trial, this is during a pretrial hearing, the prosecutor argued that it was admissible as an admission, quote, and a, quote, statement of prior knowledge. The court ruled over the defendant's objection that the rap song was admissible, provided the people were able to present someone who was qualified in slang to interpret the lyrics, since there were terms used that were, quote, not within the ken of the average juror. So you guys are going to play jury. When we get to this more details, I want you guys to play the average juror. And see if you can make something of these lyrics without needing a gang expert to interpret the slang for you. Oh, man. The following morning, the prosecutor informed the Supreme Court that the people had no expert witness available to put on the stand, and the court stated that the people would be given 10 minutes, quote, that's a quote, 10 minutes to get somebody to be their expert. The people then produces their proposed expert, detective investigator Kolawole Olasunde, hereafter the investigator. They're just going to use lowercase for him. All right. Who worked in the Special Investigations Unit at the Kings County District Attorney's Office. The investigator, who had never previously been qualified as an expert in, quote, street lingo, primarily described his duties and responsibilities in his current assignment, which included participating in debriefings and, quote, self-driven investigations of criminal street gangs. What does this mean? You're just going and investigating things by yourself, not even in the course of duty? This is very interesting from a qualified immunity perspective. If this same detective is ever, like, in a civil suit where somebody is accusing him of, doing something that's beyond the bounds of his duties, oh, I am pulling this quote. Yeah, I just participate in self-driven investigations. Not in the course of your duty. Do you do that often? Oh my God. As well as other drivers of violent crime. As part of those investigations, he interviewed suspects and witnesses and listened to recorded telephone conversations from Rikers Island. The investigator testified that he had listened to certain of the Rikers Island calls from this case, and that he was familiar with, quote, some of the vernacular or terms used in those calls. Well, this is problematic. So let's let's say, for example, we can take at face value, we just accept it as true for the sake of argument, here's some food for thought, that this investigator is an expert in the slang terms that he recognizes. It would still be problematic to me, because if you only recognize some, not most, not at least half, not majority, not almost all, some to me implies less than half. Really, I'd argue significantly less than half. So I only have a partial understanding of some of these words, taking it at face value that he's an expert on those given some words. Are you an expert in interpreting the full thing in context if you can't understand other words that are used as part of that context? But anyway, I think we're going to see that his understanding of those some words might not be all that up to par. And Aaron says, so nobody asked him to do all that, and he's just nosy. Yeah. Yeah. Also, did you hear us mention New York? Did you hear us mention New York? Shout out to Chloe. Good to see you. Hope you've been doing well. Thank you for the super. Says, maybe the people should stick to prosecuting vigilantes in Hell's Kitchen. Be careful, the blind one's a lawyer. I loved the first series of that show with Vincent D'Onofrio. I never watched the second one, but now I'm going to add that to my list because you're reminding me. But thank you. Thank you for hanging out with us. You're going to be Miss New York for the day. And thank you for the addition to my watch list, my ever-growing watch list of things I need to catch up on. So let's get to these some words, guys. Let's get to these some words. He testified that he took the same approach in trying to decipher, trying. What does trying imply? From a regular conversation. So he's trying to decipher slang from a regular conversation. If it's a regular conversation and you're still trying to decipher it, is that something that requires an expert? Is it a regular conversation, or is it a secret coded, cryptic conversation? And if it's regular, why do you need an expert? But he did this as he did, quote, when listening to an artistic expression such as a rap song. So he's saying it's an artistic expression. Why? Guys, this is a lot. We need the trial transcripts. New York courts are not very good with cameras in courtrooms. They're not very sunshiny, not very transparent. So I doubt that there's, footage of this trial. And transcripts are so expensive in New York too. It's like $5 a page if you wait for a long time for the court reporter to turn them over. And even more per page if you need them right away. It's stupid. But this might be some of the greatest trial testimony reading of all time. This guy is really up here saying he's qualified, he's knows some lyrics, and he was trying to decipher a regular conversation, and he learned how to do so while listening to artistic expression and rap music. Have you guys ever seen, like, Stan Wars? Like, Nicki Minaj and Cardi B, they have their fan stan communities. And whenever one of them drops, like, a lyric that might be beef with the other artist, there's, like, there's so many interpretations from both groups of what those lyrics mean. And within each of those groups, there's diversity of the interpretations of what a single, like, 5-word bar might mean. Do you think interpreting lyrics is a great way to become an expert in lyric and slang interpretation? Like, what? Oh my gosh. And holy moly, STS just dropped 20 gifts in the chat. Let's get some STS, and you guys know the drill. Show some love. If you just turned green, make sure you're saying thank you to STS. He heard we're talking about gangs and said 20 of you need to be initiated today. So big thank you. Big thank you. He says he's glad to be back. I'm glad you got to catch this live. I feel like I started early enough today. But big thank you, stream sponsor. STS is sponsoring our expert education on rap lyrics today, you guys. And it is a hot mess. Let's see. Following the investigator's testimony, defense counsel objected to qualifying the investigator as an expert, arguing, among other things, that he lacked the requisite experience. I mean, can you imagine being a defense attorney and just, we object, all right, what's your argument for the record? I would just be like, and just like usher my hands at the expert / investigator on the stand. Like, why do you oppose? Why do you object to his testimony? Additionally, defense counsel noted inter alia that the instant case involved an artistic expression. Oh, and this is in quotes, not just a conversation. In this regard, counsel asserted that one writing poem or a rap song has to, quote, fill the lines or make something rhyme. And quite often, there's extraneous language. Counsel contended that the defendant would be unduly prejudiced by qualifying the investigator as an expert because the jury would, quote, accept his version of how he interprets this ... rap song without anything to support the accuracy of such interpretation. And as much as we're laughing, right, we get together, like, if there's lyrics being used in a prosecution, there's like 300 people watching this between YouTube and Twitch and Twitter. We run, right? We run to this stuff. We're like, oh God, here we go again. But I think when it comes to, the average person, and, maybe you try to whittle out people that can't think creatively during the voir dire process. But I do think a lot of people put weight into testimony coming from an expert, and then also perhaps he was in uniform. I don't know if we're going to find out if he was in uniform or not, but, or like wearing like the DA badge, or if it was known, they heard his working history. Some people just inherently put trust in the testimony of witnesses that come from a position of prestige, or where you're supposed to have integrity, where you're supposed to be honest. So as much as we all think that this is ridiculous, the way that we've seen lyrics be interpreted, social media posts be interpreted, and always interpreted as if there's only one thing that this thing could mean, and it means the exact thing that we need it to mean. We laugh at that because it is ridiculous, but in the context of the courtroom with the jury, it is seriously prejudicial because you don't know if the jury is going to sit there and just take it at face value because they're told that this judge has found this person to be an expert in the thing that he's going to tell you about. The judge is telling you they're an expert. So, at the conclusion of the hearing, the Supreme Court, this is the trial court, qualified the investigator as an expert in the field of slang. The trial. So we're not even at the trial, guys. As relevant to this appeal, the people presented evidence at trial that the shooter fled the scene in the gray Nissan, which was being driven by the defendant. The people's evidence also included cell site records and surveillance footage, which demonstrated that prior to the shooting, the defendant drove behind the victim's van for approximately 40 minutes before both vehicles came to a stop at the same red light where the victim was fatally shot. All right, so we'll probably get more information on this, but remember, we have the shooter that's never identified, and then we have Reaves, who was, indicted as being like the person that was driving the vehicle, but not the actual shooter. The people also introduced the testimony of the investigator, who testified as an expert in slang. The people played the entire rap song for the jury and asked the investigator to provide a line-by-line interpretation of what he thought the lyrics meant. Oh gosh, here we go, guys. In relevant part, the prosecutor asked the investigator to interpret the following lyrics. Boy always effed up, but he wanna drill N-word. The investigator initially provided a myriad of interpretations. And again, myriad means a ton, right? This is colorful language by the justice that's writing this decision. He provided all these interpretations of this thing that he's supposed to know what the interpretation is supposed to be. He explains that the verse, boy always effed up, could mean you're poor, you don't have money, or effed up as in high or otherwise inebriated, or something that makes you impaired. So it could, boy always effed up. I could think of other things this could mean, but right there he's already given us two options. Effed up could mean, he's always getting in fights and getting beat up. He continued that the verse, but he wanted drill and N-word contextually read in perfect accord with the people's theory of the case, as someone who might be impaired but wants to be involved in a shooting. So what? So this lyric means that somebody's drunk and wants to be involved in a shooting. But these lyrics seem like they're talking about somebody else, right? It doesn't seem like Reaves, who's writing and like performing these lyrics over a jail call. It seems like he's talking about somebody else anyway and not himself. So are they going to say he was talking about the person he was driving? The prosecutor turned to the following lyrics. Quote, no food, no bud, so I swipe for an N, life for an N. Talk about the bag getting hyped up with an N. Although there was no allegation in the indictment regarding the illegal use or possession of credit cards, the prosecutor elicited from the investigator that, quote, swipe meant the use of fraudulent or otherwise illicitly gained credit cards or EBT cards, or any number of methods of swiping or gaining money or food items for someone. Swiper, no swiping? Couldn't swiping just mean stealing without credit card fraud? Like, you go and you swipe a candy bar. Why do we need to make it so much more egregious that it means the fraudulent use of illicitly gained credit or EBT cards? Why do we have to, elevate it? The investigator also testified that the bag is getting money or getting rich or enriched. The prosecutor then turned to the following lyrics. I said, boy circle effed up, so I'm seeing him alone. They wasn't really jacking him. There's an ellipsis here, so I don't know. I mean, it seems like it flows. Maybe they didn't know what was being said there. They wasn't really jacking him, so he ply him with the chrome. The investigator opined that the phrase, boy circle effed up, referred to the person or people he surrounds himself with are somehow impaired. Or his circle's just not there for him. They're messed up. They're people. That person's effed up. They're not his friends. So the whole circle's just drunk or impaired. Adding that he guessed it meant they're not cohesive or good people. I think this is a better interpretation, that they're just not protecting him. The investigator first acknowledged that the term jacking had a variety of different meanings, but then asserted that contextually here, it meant they wasn't promoting him or representing him or embracing him into their circle. The investigator testified that the verse, so he ply him with the chrome, meant to supply him with a firearm. I mean, maybe shorthand to make it rhyme. Notably, and once again in complete accord with the people's theory of accomplice liability, the investigator opined that the previous verse coupled with another verse, the drill A, referenced using that firearm in the commission of a shooting or homicide or serious assault. The prosecutors also addressed the following lyrics. There's more. I said, heard about your come up and drove him to the bump. That wasn't your drill, that was another end's target. The investigator explained, well, then hold on. If this was supposed to be somebody else's beef, is this where they're going to say there was a plan, but they executed the plan wrong, but this is their evidence that it was pre-planned? Because remember, Reaves is, it's supposed to be that he was complicit in helping to facilitate the crime that was committed by somebody else, that crime being the murder. So the other person, the unidentified shooter, still don't know who the shooter is the other person. But because they have the cell site data, they're trying to at least win a conviction with Reaves, right? And saying that he knew that this was going to happen. So is this supposed to be there was a plan to shoot somebody, but they shoot the wrong person? All because of lyrics being rapped after the fact. Okay, wait. So lyric starseed. So is swipe no swiping specifically like using a card, or it can be any type of you just swipe something? So let's see. I'll try to keep a look here. Um, let's see. Where was I? The investigator explained that heard about your come up might indicate a promotion, gaining money, or somehow or another betterment of your prior circumstances, and that bump meant a location where something is going to take place, such as a home or a street. Additionally, and in perfect symmetry with the people's factual theory of the case, the investigator testified that this wasn't your drill, meant you weren't supposed to be the one that did the shooting, and that N's target meant another person's target. So that is the route that they're taking. He then stated, in the context of the surrounding lyrics, come up might be in reference to a contractor paid shooting or a homicide or assault. Significantly, a contractor paid killing is an element of murder in the first degree, which was not charged in the indictment. Hold on. I think we have something to... I don't know if it's going to be the right one. I think it's this one. We've got another thing to open. Hold on. I have the package down here. I just don't want to show it because my address is probably assumably visible. Okay, yeah, this is the right one. So this quote is coming out of the Cop City RICO, which is no longer a RICO case, but it's the indictment could be better shirt. Probably reads backwards since it's, I think my camera might be mirrored. But the indictment could be better, which is what the state in the Cop City RICO case told the court, that their indictment could be better. I think it applies here. I got it. It took like a week and a half maybe to get here, Aaron. But I've had it for a little bit. It's just I haven't streamed. Okay, so lyric says specifically swipe or no swipe or swipe no swiping is specifically using a card. All right, so and I get it because it's a swipe motion, but I always just looked at swipe as just like thieving something in general. I'm waiting on my my WWBD shirt. Also, Chloe says I'm a wrap expert, aluminum and cling specifically. You know what? That's pretty serious because cling wrap that's expert level to deal with cling wrap. It's not I don't get along with cling wrap. So if you're an expert in that, that's actually something to be proud of, for real. Good old Chloe. All right, so we've got in the context of the surrounding lyrics that come up might be in reference to, I think we read this, a contractor paid shooting. Significantly, a contractor paid killing is an element of murder in the first degree, which is not charged in the indictment, despite the reference to a contract killing being evidence of an uncharged crime. The people continue to elicit similar testimony by asking the investigator to define the verse, taken slugs for a pretty penny, which the investigator interpreted to mean that the contract was not particularly lucrative. They're not going to interpret what taken slugs means? And it's plural, not just one contract. So it's in relation to something that isn't even charged in relation to this indictment. And it's plural, but this gang expert investigator witness, it's about this one contract that relates to what the state is trying to tell you guys here. The investigator also testified that the verse, "I said no bread, so I took you to the ling," contextually might mean the place where you get money, ATM, bank, or house, or any number of things. It can be a check cashing place or the place where somebody is going to pay you. The prosecutor then asked the investigator to interpret the following. Quote, "But fake love, cause you're, it says OP, but it's supposed to be op, and knew them brothers. Chris Paul, what?" And it's funny because Chris Paul, if you're not looking at the screen, it's like knew them brothers, ... There's an ellipses. Chris Paul, no Chuck. I knew them brothers first. Chris Paul, get him in the indictment now too. What? Oh my goodness. The investigator testified that Chris Paul was a National Basketball Association point guard known for passing the ball, meaning giving an assist. The investigator opined that Chris Paul reference, used in conjunction with other phrases, indicated the author took pride in providing assistance, quote, generating that introduction between the subject of this rap poem, rap, expression, and the person to whom they were introduced, the brothers. He knew them first. The investigator acknowledged during cross-examination that deciphering rap lyrics was different from interpreting like regular conversations because rap lyrics incorporated similes and metaphors. The investigator further acknowledged that rap lyrics were not always literal and could have double meanings. The investigator also conceded that nothing in the rap lyrics were suggestive of a timeline. Lastly, the investigator acknowledged that, during a recorded conversation, the defendant stated, "My son gave me a few, like 3 bars," which indicated that the defendant was not the sole author of the rap song. The investigator opined that the statement suggested someone else gave the defendant 3 lines or 3 elements of the rap poem, but that there was no indication as to which specific lines those might be. So is this like facilitation within facilitation? Are we facilitating the confession through the jail call rap song performance? Somebody else, can we indict the person that helped with these lyrics? At the close of the people's case, defense counsel moved to dismiss the charges, arguing that the people failed to set forth any evidence proving that the defendant knew the shooter had a gun or intended to kill somebody. In response, the people argued, inter alia, that the defendant's conduct prior to the shooting, coupled with the rap song, clearly demonstrated that the defendant knew that the shooter intended to kill someone. The Supreme Court denied the defendant's motion. Following the trial, the jury found the defendant not guilty of murder in the second degree, but found him guilty of criminal facilitation in the second degree. So they, maybe, who knows what the jury thought. The defendant appeals. So let's get to the legal argument. Yeah, nested hearsay. Oh my gosh, we need the accidental tab. Oh, showing the wrong tab, but it's Bruce Harvey's picture. Yeah, Son is the third party culprit. Who is Son? Who's Dude? We've got to unsun this reference. Oh, man. Actually, did I upload? I don't know if I uploaded the GIF with the Bruce Harvey ponytail swipe. I don't see it, but I need to do that. Because you never know when you need it. All right, so on appeal, the defendant contends, among other things, that the evidence was legally insufficient to support his conviction and that he was deprived of a fair trial by the admission of the rap song through an unqualified expert. Initially, contrary to the defendant's contention, viewing the evidence in the light most favorable to the prosecution. So initially, remember we did a thought experiment at the beginning of this, like let's take this at face value, let's just assume. Initially, contrary to the defendant's contention, viewing the evidence in the light most favorable to the prosecution, we find that it was legally sufficient to establish his guilt beyond a reasonable doubt. Moreover, in fulfilling our responsibility to conduct an independent review of the weight of evidence, we nevertheless accord great deference to the jury's opportunity to view the witnesses, hear the testimony, and observe demeanor. Upon reviewing the record here, we are satisfied that the verdict of guilt was not against the weight of the evidence. So they don't want to revisit the facts. They're not going to challenge what the fact finders, the jury, found. However, we find that the defendant was deprived of a fair trial based upon the improper admission of the rap song through a witness who was unqualified to offer expert opinion testimony regarding the meaning of the lyrics, and whose interpretations were often grounded in admitted speculation, but which ultimately evolved into opinions fitting precisely into the people's factual theory of the case. Although the defendant's challenge to the improper admission of this evidence is partially unpreserved for appellate review, we nevertheless review the issue in the exercise of our interest of justice jurisdiction. They want to set a precedent here. So they're saying didn't really properly preserve this for appellate review, but we want to take a look at it. So shout out to this court. A number of courts have recognized that rap music is a form of artistic expression that often contains non-literal references to criminality and illicit conduct. Accordingly, courts have cautioned against the improper admission of such evidence. So they're citing it, from an Eastern District of New York case, United States v. Jordan. I think that was I have to look at that. I feel like I remember this trial, but don't remember the appeal. But here we have a little quote. It may not be surprising that nearly every rap album in the Billboard Top 200 today contains references to drug use, drug sales, violence, or some combination of the three. And thus, one cannot necessarily infer criminality simply from a rapper's reference to violence, drug dealing, and the like. We've got United States v. Wiley. Some courts have expressed concern that the fundamental nature of rap music as a form of artistic expression that frequently features aggressive and hyperbolic language would pose too great a risk of undue prejudice. We've got United States v. Williams, noting that rap songs are a form of artistic expression, and as with any artistic expression, it is difficult to distinguish between reality and fantasy. And then State v. Skinner. Extreme caution must be exercised when expressive work is involved, particularly when such expression involves social commentary, exaggeration, and fictional accounts. So, however, both state and federal courts have held that, under the appropriate circumstances, rap lyrics may be admitted into evidence at criminal trial. We've got a footnote here that says the United States Court of Appeals for the Second Circuit. So this is the appeals court. We're reading the decision from this court. So they're referencing themselves. Has held that rap lyrics are properly admitted where they are relevant and their probative value is not substantially outweighed by the danger of unfair prejudice. They're citing also the Jordan case again, that the United States District Court for the Eastern District of New York, relying upon federal court precedent, concluded that a rule of thumb has emerged from court decisions that have considered this issue. The relevance of rap lyrics as trial evidence depends on the existence of a specific factual nexus. So, if you want to say that it's relevant, is it for the rules of evidence? Is it relevant? There has to be a specific factual nexus between the content of rap music and the crimes alleged. Now, we have an issue here, a particular issue. I think this court found that there were several issues with the lyrics testimony and the qualification of this expert. But remember, one of the specific issues is, they're referencing a contract killing. But there is no contract killing in the indictment. It's second-degree murder, not first. So, by that alone, because the indictment's not good enough, you can't have a specific factual nexus to the crime alleged because you aren't alleging the crime. And the holding here, we've got United States v. Carpenter holding that rap lyrics and rap music videos were admissible since they spoke with specificity to the precise conduct with which the defendant was charged. All right, so that was the footnote. Oh, man. For instance, rap lyrics have been admitted where they were relevant to the issue of a defendant's knowledge and intent, or as evidence of the defendant's consciousness of guilt. And we got a footnote here that says the defendant notes that New York has proposed legislation to amend the rules of evidence to limit the admissibility of a defendant's creative or artistic expression in a criminal proceeding. So this is New York Senate Bill S 1738. Like Fetty Wap? Isn't that like a label? Isn't that a group? Is that a coincidence that they did 1738? If it's not a coincidence, that's great. And then New York Assembly Bill A 127. The proposed legislation would require the people to overcome a presumption of inadmissibility of evidence of a defendant's creative expression by proving through clear and convincing evidence that A, literal rather than figurative or fictional, meaning and, where the work is derivative, that the defendant intended to adopt the literal meaning of the work as the defendant's own thought or statement. Or B, a strong factual nexus. And there is no and or, so maybe it's an all. Maybe it has to meet all of these things. That there must be a strong factual nexus indicating that the creative expression refers to the specific facts of the crime alleged. C, relevance to an issue of fact that is disputed. And, so we've got the and. It's got to be all these things. Distinct probative value not provided by other admissible evidence. So you can't just, even if we have all the other criteria met, we can't just bring in lyrics to bolster something that we've had other testimony for. We can't just use lyrics to bolster our case. Let's see. Oh, cool. Does this click and open? Oh, I was gonna link to it, but this press release link, it says, we're sorry. We're sorry. But yeah, there's some link that's not working in the footnotes there. Let's see. And hold on, let me reopen this. I don't know where we were, but this just reloaded itself. So let's find that footnote. There was the Chris Paul reference. Let's see. All right, so we finished off with this footnote. It went on to another page. It finished off this page. And we're back to regular text. We've got rap lyrics have also been the subject of expert testimony at criminal trials. People v. Green, Mendoza v. Cates. In general, expert opinion testimony is appropriate when it would help to clarify an issue calling for professional or technical knowledge possessed by the expert and beyond the ken of the typical juror. And where is... Hold on now. Where is lyric? Lyric. And I don't know if you're from New York, right? But if you are, like, let's say you're in the jury pool, because the way I read your comments, it's like, here in New York, like, this is how we use it. That would mean it's not beyond the ken of a jury of peers, albeit, let's hope that voir dire is done fair and intelligently. You came in and you're like, well, no, this is what this means. And during deliberations, you could be in that room and say, well, they're trying to introduce, and I don't think these lyrics would be admitted if they didn't have a gang expert at all, right? It just wouldn't have been able to come in. But it's coming in because the jury can't interpret. But lyric showing us you're not a qualified expert, although, by this standard, you absolutely could be above and beyond what was qualified as an expert here. Like, how is this beyond the ken of a jury? The conversation that you brought to the chat here is exactly what I would hope would go on in a deliberations room. So, let's see. In general, expert opinion testimony is appropriate when it would help to clarify an issue calling for professional or technical knowledge possessed by the expert and beyond the ken of the typical juror. And if I was in that deliberations room with you, I would be like, well, either way, it's still a lyric, right? Like, swiping with a credit card, is that alleged here? Like, is this what this guy's on trial for? Is it just a lyric? Like, they saying they do this all the time, multiple times. Does that mean they really did? So, I think I always love to see a court acknowledge that, something that's being preached like it's the gospel by an expert witness that also happens to be an employee of the state, the revolving door. It's not really some expert knowledge. It's really just the state putting someone on the stand that's going to bolster their own theory. And it's going to mislead the jury, who could otherwise interpret these things for themselves as the actual finders of fact. So, and Aaron's on it. Thank you, Aaron. Aaron posted a working link here to, I think it's a press release about the bill, about artistic expression and use in trials, and rules of evidence that we hope we can apply when the state seeks to introduce lyrics into trial. Let's see. Now we're going to get some more commentary. I'm excited for this. The meaning of coded communications is a proper subject of expert testimony. Law enforcement officials have been qualified as experts to testify concerning the meaning of street slang used in recorded conversations, as well as coded communications by narcotics traffickers, gangs, and pimps and prostitutes. The admissibility of expert testimony is generally addressed to the discretion of the trial court. So the court is acknowledging, like, cool, we understand why this exists. We understand the role it plays. And it's a bit more specific here, right? We're dealing with coded communications, things that are meant to be a communication, maybe to direct action, rather than lyrics, artistic expression, and performance. However, to be qualified to offer expert opinion testimony, the witness must possess the requisite skill, training, education, knowledge, or expertise from which it can be assumed that the information imparted or the opinion rendered is reliable. The expert's opinion, taken as a whole, must also reflect an acceptable level of certainty in order to be admissible. Under the circumstances of this case, we find that the people failed to establish that their proffered expert witness was qualified to render an expert opinion as to the meaning of the rap lyrics. After the Supreme Court that's the trial court, gave the people 10 minutes to get somebody. Got sprinkle. The people proffered the investigator as their expert. Although the investigator testified that he had attended trainings regarding gangs, including gang lingo, this case did not involve gangs. We've got a long footnote. Moreover, even if the investigator were properly qualified to provide expert testimony on gangs, it does not necessarily follow that he would be qualified to provide expert witness testimony on rap lyrics. Oh, I love that. Love that. They cite United States v. Williams, noting that a Bureau of Alcohol, Tobacco, Firearms, and Explosive Special Agents, so ATF, who had investigated a gang in which the defendant allegedly was involved but had no training or prior experience in interpreting rap lyrics, was clearly not an expert in interpreting rap lyrics, noting that a police officer, this is Commonwealth v. Gray, noting that a police officer who has been qualified as a gang expert cannot, without more, be deemed an expert qualified to interpret the meaning of rap music lyrics. Well, shout out to this finding here. Just because you're a cop doesn't mean you're an expert in gangs. People v. Wright, holding in a gang-related case that expert gang testimony regarding the meaning of defendant's rap lyrics was properly admitted. All right, so back to the text. Moreover, the investigator gave a variety of interpretations for the same lyrics, and even admitted to guessing as to some of his interpretations, but he then consistently offered opinions that invariably inculpated the defendant in the precise way the people argued the defendant participated in the charged crimes. Crucially, these interpretations bolstered the people's theory of accomplice liability, that is, that the defendant had prior knowledge of the shooter's intentions and even supplied the gun. Separately, the investigator also indicated that the defendant was not the sole author of the rap song, and that the investigator could not determine which portions had been written by someone else. The admission of the investigator's testimony concerning his interpretation of the rap song was the people's only direct evidence of the defendant's mental state prior to the shooting. So, without that, can they convince another jury of the required elements of the crime? And remember, the jury acquitted him of count 1. So this retrial, the jury cannot convict him. They're not going to be asked to even consider count one. It's gone. He's got the acquittal on that. So this is just going to be, did he facilitate? Did he know? Did he know that it was probable that this thing was going to happen? And did he help facilitate? They go on to say that without the investigator's testimony, the people failed to establish the relevancy of the rap lyrics to the circumstances of this case. We've got a footnote here. Let's see. The rap song, as interpreted by the investigator, also referred to gang affiliation, and there was no evidence that this case involved gangs. So this is why they, in the other footnote, they cited a case that, hey, you can admit this, and it was a gang-related case, but because that holding said this because of this, if we're missing that one element here, then you don't get the benefit of doing that in this case. For example, the investigator interpreted the lyrics, gang was his brother, to mean the person to whom he was being introduced appears to be in a gang or in a crew. Okay. Indeed, the rap song was replete with language that was beyond the ken of the average juror, and according to the investigator, was open to a variety of interpretations. Further, the error in admitting the investigator's testimony concerning his interpretation of the lyrics was exacerbated by the fact that his testimony also described prior bad acts and uncharged crimes. This testimony was offered in the absence of the Supreme Court applying the required Molyneux balancing test. So when we hear Molyneux, it's a case that is from New York. So in a New York case, when you're dealing with bad character evidence, prior bad acts, typically they'll call that Molyneux evidence rather than, maybe it's Molyneux. Molyneux evidence, I don't know. But it's their way of saying bad character, prior bad acts evidence in New York because of this case. Regarding the admission of such testimony, they also cite People v. Leonard. Multiple uncharged crimes were attributed to the defendant. For example, the investigator testified that the lyrics, "So I swipe," hey, we're getting this again. "So I swipe for an N" meant in pertinent part that the use of fraudulent or otherwise illicitly gained credit cards or EBT cards. There was no charge in this case relating to the illegal use or possession of credit cards, and this testimony was entirely relevant to the issue of whether the defendant knew the shooter intended to kill the victim. There we go. So this interpretation that's, as Lyric gave us the context for in New York usage is not helpful for the state as it pertains to this appeal decision. Because it's so much more specific. It's not just stealing something in general. He's not even accused of stealing something in general. But these lyrics are interpreted to relate to something that is just absent entirely from the indictment, from the alleged crimes. Additionally, the investigator, because what if it was just swiping or something? And you're trying to steal from the person that was killed, and that's how the shooting ultimately happened. Or it was get back because somebody robbed somebody else. Maybe you could get to arguing a nexus. But with this lyric interpretation, the nexus would have to be we were running some operation involving the use of illicitly gained credit card and EBT cards, and somehow it involved the victim. And that was the reason behind what we did. So this interpretation from the gang expert became a huge appeal issue here. Additionally, the investigator testified that the lyrics, "That wasn't your drill, that was another end's target," suggested a hired hit. The investigator also testified with respect to the preceding lyrics, "Heard about your come up." That come up could mean money within the context, such as a contract or paid shooting or a homicide or assault. The defendant was charged with murder in the second degree, and this testimony improperly suggested the defendant was guilty of murder in the first degree by having been involved in a murder for hire. The prosecutor compounded this error during summation. Oh boy. What did the prosecutor do in closing arguments? Oh my God. The prosecutor compounded this error during summations by repeatedly referring to the circumstances of the crime as a paid hit. An uncharged and inflammatory allegation based on the investigator's interpretation of the rap lyrics. I can hear it. I can hear the closing argument in my head. You heard testimony. This was a paid hit, and then he bragged about it on a jail call. He's proud of it. Paid hit. Oh my god. The prosecutor argued, among other things, that this was a hit. Quote, one can infer the defendant would be getting paid for it. Quote, the defendant gets paid for helping the shooter carry out that hit. And, quote, everything in the defendant's rap song that was another person's target, this was a hit. The prosecutor repeatedly referred to the shooting as a hit, making this reference 12 times during summation. Chat, everybody drop, this was a hit in the chat. Guys, why do prosecutors do this? They didn't even say, I submit to you. They just said, this was. They could have said, I submit to you this was a hit. Accordingly, for all these reasons, the Supreme... And notice, this isn't argued, right? We didn't hear that the defense argued this in appeal. You know, maybe they argued it earlier in a motion to set aside the verdict or vacate the sentence with the trial court. But it doesn't seem like an issue that was raised in the brief that led to this appeal decision. This to me seems like this appeals court, like, we've got to put this in writing. Because, bro. Colonel says this sounds like a Hilton and Love summation. Hilton would have said, I submit to you. She would have yelled. She would have been like, I submit to you, and then yelled that this is a hit part so you'd hear that louder. But I think she would have at least said, I submit to you. Oh my gosh. Hey, Allie, good to see you. We've got Christine Fortunato. Good to see you, Christine. Thanks for being a member for 11 months. Holy moly. That's a whole year almost. Right up on the cusp. Hope you're doing well. Yeah, Aaron says, do we have some burden shifting? It's burden shifting that this court wants to call out. It doesn't seem like it was a raised issue. But yeah. Let's see. I submit to you this is a hit. That's, you know, it could have been a little better if we said that. This is a hit. This is a miss. This is a hit. But was there a red bike? Oh, man. And this prosecutor, you know, what's interesting about New York, some decisions you read and you don't get headers like this, but we get this little caption. Do we have... Well, these are the justices. Aha, here. I don't know if this was the trial prosecutor, though. It just says the district attorney of Brooklyn. And then we have Leonard Joblov, Keith Dolan, and Kirtana Nina of counsel. But this could be, maybe they weren't trial prosecutors. But I don't know if this is one of the three. I don't know if this is our summation person. But they didn't give us a name. They didn't give us a name. This was a hit! Oh my gosh. Where were we? Alright, the 12 times. Accordingly, for all these reasons, the Supreme Court, the trial court erred in admitting the rap song into evidence through the testimony of the investigator. Therefore, the judgment must be reversed and the matter remitted to the Supreme Court, Kings County, for a new trial on the count of criminal facilitation in the second degree. So, again, this new trial is only going to be for this second count. Count 1 is gone. He was acquitted. In light of our determination, we need not reach the defendant's remaining contentions. Oh, I want to see them! Accordingly, the judgment is reversed. on the law and as a matter of discretion in the interest of justice, and the matter is remitted to the Supreme Court, Kings County, for a new trial on count 4 of the indictment, charging the defendant with criminal facilitation in the second degree. And then so ordered. This was Daryl M. Joseph writing for the court. Hey, Jeannie. Oh my gosh. Phoenix says, I knew this was going to be a hilarious breakdown. I want you guys, when you guys see like a thumbnail pop up and there's a case and then you see that it's me, I want you guys to hear the sigh before the stream even goes live. Because this is, and obviously we're funnel visioning to cases like this, but there's a lot of them. There's plenty to go around. It doesn't seem like there's a shortage of stuff like this. But it is really nice to get in the form of an appellate decision, right? A lot of the time we look at the mess in the terms of arguments and motions or, appeal briefs before a decision's actually granted or rulings issued by the trial court or appellate court. And that's only argument. But now this is a decision. This is a reversal of a conviction. There's going to be a new trial. And they're stating, we want to take this time to give you an additional argument here in the interest of justice. We want to set the precedent that we can't just be putting people up here, calling them gang experts, letting the court qualify them as gang experts, and then they just mirror the state's theory of the case, and then improperly introduce bad character evidence that the prosecution then uses in closing. And this is important because maybe without this, this court might have said, we don't think it was that impactful. We don't think that the jury wouldn't have reached this conclusion if not for the admission of this, investigator and these lyrics. But when you have the prosecutor hammer it home and make a conclusion, they make the conclusion for the jury 12 times in their closing argument, all of that together, how can you not say that that's reversible, that that's harmful error? It's not harmless. So, a hot mess. I also, at the beginning, so sometimes when I see a case like this, I try to do a keyword search, see if there's, other little details out there. And while I don't believe that Eric Sanders, and he seems familiar to me, so I just followed him. But when I searched for Reaves, this tweet came up, this X post came up, and he's got some commentary, so we're going to read it, but there's a point here, some context here that goes beyond this case that I thought was interesting. So let's take a look. So, Second Department exposes junk science in Reaves case. So this is the appeals court that just issued this decision. This week, the Appellate Division, Second Department, overturned the conviction of Idrissa Reaves, who had been found guilty in 2019 of criminal facilitation connected to a Brooklyn shooting. The problem? The trial court let the prosecution parade an expert who wasn't qualified to be one. At trial, this is the trial court judge, Justice Vincent Del Giudice, allowed a detective with no history of being accepted as a street lingo expert to testify about the meaning of rap lyrics prosecutors said Reaves co-wrote. Unsurprisingly, the detective's interpretation wasn't neutral. It, quote, precisely and remarkably mirrored the people's theory of the case. In plain English, the so-called expert told the jury exactly what the prosecution wanted them to believe. The Second Department wasn't fooled. It ruled the testimony inadmissible, stressing that Reaves did not get a fair trial. A new trial has been ordered. This reversal fits a troubling pattern. So this is where I thought, over his career, Justice Del Giudice, this is the trial judge, has been overturned repeatedly. 19 of his sentences reduced on appeal as too extreme, cutting more than 500 years off total prison terms. When higher courts intervene this often, it raises serious questions about fairness, judgment, and judicial restraint. 19 sentences reduced on, and this is just dealing with sentences. So I don't know if there's other cases that have been overturned and sent back, remanded for trial. But the example here that Sanders is giving us is that 19 times on sentences being too harsh, too extreme. And remember, trial courts have a degree of discretion. And maybe some of these sentences were, errors of law, like the sentence was beyond the statutory limits. But the way this is worded, and this is just going by Sanders' post, is that it's possible that the courts were like, the sentencing, the discretion, it might have been within the terms, but the reasoning that the court gave, the discretion, not acceptable. So this was really interesting. And again, this is limited context, but really interesting here to see from, and let me drop the link to this post in the chat for you guys. So there's that. And he goes on, he says, the Reaves case is about more than one conviction. It highlights how courts have allowed junk expert and prosecutorial shortcuts to invade the fact-finding process. And we talked about in evidence, the link that Aaron shared earlier, it's proposed legislation to, establish some requirements for the use of lyric evidence and anything that could be considered forms of artistic expression to be admitted as evidence in trials. But separate from that, about a year ago, there was proposals to, I forget which direction it went. All I remember is that prosecutors who are intertwined with politics, prosecutors were crying. They were throwing a fit, like a tantrum, because they were worried that sanctions were too harsh. Sanctions against prosecutors who violated Brady, Giglio. We're worried that the sanctions are going to have a chilling effect on our pursuit of justice. They're going to have a chilling effect on victims if you allow courts to have wider discretion in how they sanction us for not doing the things that we're supposed to do. And prosecutors were crying over it, and it was an issue that was attached to some big bill that was contentious over in New York. I'm sorry I don't have like a front of mind recall on the issue. But the point is that these New York DAs, these prosecutors in New York, are constantly fighting to have more leeway, to be able to maintain their ability to take shortcuts. For courts to continue to allow the admission of testimony and evidence like the song and the expert testimony in this trial. Just a clear-cut path to a conviction. Because if you don't do it, it's going to have a chilling effect on victims if you don't let us play the game this way. So, but yeah, I think this point right here is it highlights that prosecutors want these shortcuts. They don't want to follow a proper fact-finding process. And then undermining the jury's role and eroding public confidence in law. And let's see, I think this is the judge here. So yeah, Honorable Vincent M. Del Giudice. With the green pencil. This must be the pencil he uses. He's got the slime green pencil eraser, chat. Oh, man. Oh, just rounding it out with one more bingo card. So there we go. And let's see. Okay, so I wanted to read this bio. I don't have to open. Let's see. So Eric Sanders says he's a civil rights attorney, does sexual harassment and police misconduct advocacy, and he's been featured on... He's got quite a bio here. He's former NYPD turned attorney. He's a panelist and speaker at Columbia Law, St. John's Law, and other legal symposiums. Recent recipient of the NAACP Keeper of the Flame Award. So there you go. Interesting to see this commentary on the case and the extra context there about this judge. Kind of crazy context. I think that wraps it up for our Reaves stuff, you guys. Yeah, insufficient investigators, prosecutorial laziness. Aaron says the way it's worded makes me wonder if some of the sentences were for juvenile defendants. Ugh. It's harsh sentences for the sake of harsh sentences, not something that I love, but within the context of like juveniles, separate law for juveniles, separate process for juveniles for a reason. supposed to be of a ripe young age where, the question of, can this person be a productive member of society? Will they reoffend? It's supposed to be a different interpretation when you're dealing with somebody that's of a younger age. So that would make it even worse, even though it's like, how can it get any worse? You know? So let's see. Yeah, Colonel says rogue judge. And again, in New York, not really, doesn't really have cameras in the courtroom. This channel really, I started this channel just to put up some transcript coverage and recorded audio, like exhibits from the Dep't Heard trial that I just couldn't find anywhere. It wasn't like an exhaustive archive. It was just one that I didn't really see, so I just uploaded it, and then uploaded some handwritten letters, and that was kind of it. And then it sat and collected dust. And then I heard that Jonathan Majors was charged and arrested for strangulation, which turned out to be wholly false. Charges were dropped. There was no evidence of the strangulation. There's a dispute over, was it the cops that reported it, or was it the complaining witness who made it up? Somebody goofed, but it wasn't true. It wasn't correct. He hadn't been around for over 8 hours at the point in time where the news had reported that he just strangled somebody. So no strangulation there. When that was going to trial, no cameras in the courtroom. So had to rely on news coverage. News coverage was severely lacking. They would pull out sound bites like the word monster being used in a text message. So a bunch of us, we crowdfunded, we crowdsourced the trial transcripts, read through it. The trial was a hot mess. Hot mess. And I think it could have been totally different. The media might have been under pressure to report a little bit differently if the public had greater access, if there was camera access, or it was easier to access transcripts. So always a big supporter here of courtroom transparency. And I know things can be sensitive, right? You don't want to put a victim's experience on blast. But unfortunately, trials aren't really about the victim. They are inherently, the nature of the trial inherently involves the experience of a victim. But the trial is about, did the person that the state is accusing of this thing that involved this victim, did this person do this? Can we prove that this person did this? So, and I think transparency is the ultimate way there to, for the defendant to have a fair trial, which is their constitutional right. And I also think it's the quickest way for the public to have access, as we're entitled to trials. So, let's see. So factual lie, I caught a bit about the Amira case. Short story, woman in Florida, yeah, so she was jailed for 50 days and fined $1,000, and it was being reported as due to a petty theft at Target, but I believe the fine was in relation to the petty theft, but the incarceration was in relation to a probation revocation, right? So Target theft with fine triggers 50 days in custody because of revocation of another issue. Interesting concept to talk about here as we follow along with and watch. And I'm hoping, I didn't see Jim today. I haven't spoken to him in the last day or two, but I don't know if Jim's gonna do a live stream soon. You guys always know Happily Angry Lawyer, representing Munktunk, and now officially applying for pro hoc vice for Quintavis Greer. That's Unfunk. So waiting to see. I don't know if he'll talk too much about the Unfunk case on his stream, but waiting to see if he goes live with any updates, at least on Munktunk or Antonio Sledge. They've been working hard. Again, for Antonio Sledge, that's Tiffany Adams and Jim. For Quintavis Greer, that is Rachel Kaufman, is lead counsel, and then Jim is applying for pro hoc vice. So yeah, free Munktunk, free Unfunk. It's a bar. That's a bar. And free Lil Rod. That one doesn't rhyme. But yeah. And in factual lie, all the articles were super short. Super short on that case. So Jim's gone quiet, but he's been busy. And then, guys, so of course, the second Jim goes live, I'll try to stream it, but you guys, if the easiest way to see if he goes live is, of course, make sure you're following him. Let me drop his link. But yeah, he's probably been underlining a lot, circling things in red pen. He's been busy. He's been busy. And I say that with love. I'm joking, but I say that with love. As far as other things, I made a little doc before I went live because I know I've been absent. I've been busy with work. Unfortunately, it's not work relating to trials and cases and appeals. But I made this little doc just to give a visual. Let's see. So, things that I want to try to cover, and if there's enough material, I would want to pop on a live and cover it with you guys. So October 14th, I don't think there's cameras in this courtroom, so this might be a short community post or post on X. But October 14th, so like 2 weeks from now, is Relly, ASAP Relly, Terrell Efron, versus Rakeem Myers. This was the first personal injury case, the one where Joe Tacopina is not a party. It's not the defamation case. This case has a hearing on a motion to compel. So Relly's supposed to turn over stuff for discovery and hasn't done so. And now there's motion for sanctions. The judge in this particular case a few weeks ago, during a hearing, strongly, and I say strongly, advised Relly to consider cutting his losses and to confer with other parties, the opposing parties, to see if they'd come to some type of settlement where they would drop their fight for sanctions. This is the judge, like, Relly, cut your losses. And Relly responded to the court that he has already sunk $500,000 into this litigation. This is after Camille Vasquez and Ben Chu finally walked away. They stayed on until about beginning of September, maybe end of August, is when there was a withdrawal notice filed. So that is the first case. Is going to be an update. I don't think there's going to be a video worth of stuff happening, but whatever I see reported or what gets on the docket, I'll at least make a community post. October 15th, I want to go live. I believe this will be streamed. This is going to be a status and plea hearing for Courtney Clenny. I've been waiting for this case. Trial is set for December 1st. And this is a Florida case. So with Florida, they always do like a 10-day ringing of the bell. So 10 days before trial, we've got to set a hearing, make sure everything's straight. So October 15th, December 1st, and then like 10 days before December 1st, however that cookie crumbles. There are things that I think we'll have camera footage for, and we'll go live and we'll cover those things. Around October 15th, I think we'll also do a rewatch of the Arthur hearing. That's like a bond hearing in Florida for someone that is facing like serious charges like murder and potentially facing a life sentence. So we'll rewatch that bond/Arthur hearing that took place in November of 2022 as a rewind, give you some context on the case. I have tons and tons of content on the Courtney Clenny case. Pretty much all of the publicly available exhibits, including her journal notes saved in her phone. Videos like the Aspen, Colorado fight, the elevator. There's way more footage than was put out. Tons of stuff on my channel if you want to just deep dive into that case. But we'll go over some of the basic context as we get into this trial finally taking place. It's been like 3 years. So mark your calendar for October 15th. We'll go live that day. October 23rd, this is the Relly, Rocky, and Joe Tacopina, the personal injury defamation case, the second civil action. It's a special motion to strike. So we're going to hear Rocky's side and Joe Tacopina, because Joe Tacopina is a named defendant in this case. The theory is that Joe Tacopina made statements and interviews to TMZ and that he was acting as an agent for for Rocky in those moments, and said things that were untrue, like calling Relly's claims a hoax and a fraud. Well, Efron's suing, saying that that's defamatory. But this special motion to strike hearing, because this involves a nature of free speech, anti-slap, we're going to hear Tacopina and Rocky argue why this whole lawsuit should be dismissed on the grounds that it was free speech, protected speech. So, and even though Camille Vasquez and her firm did write some filings in relation to this issue, they're gone now. They're gone in this case as well. So it would just be Terrell Efron posed to make counter arguments. If he doesn't find another person to represent him, he could be taking on some pretty specialized arguments by himself. So I imagine there will be media applying for access to this one, and if there's no cameras allowed, that there will at least be more extensive coverage. And of course, when there's more detailed coverage, even if it's written, we can go live and we can take a look at it. But that's going to be good. October 23rd will probably just be a quick update, but Tyrone Blackburn, we've talked about some of his AI filing mess. We talked about the Fat Joe case, where Tyrone Blackburn is a named defendant. And in the midst of that, he picked up criminal charges. It's like 8-9 counts. He's accused of attempting to intentionally run over a process server with his car. So we'll look for updates on what happens with that criminal case that's set for October 23rd as well. So this might be a dual update stream, even if we don't have live feeds of anything. I don't think we'll have live feeds. Maybe we will for the Tacopina thing. But that might have enough meat on the bones to pop and do a video on. So there's that. A year ago, if you asked me, I would have said around this time I would have loved to be doing the Shayna Gardner case. That's a murder for hire trial in, I think, Jacksonville, Florida. Jose Baez representing Shayna Gardner. We've got the actual hitman kind of like pointing the finger at Shayna Gardner and her alleged co-conspirator, but then recanting after he got his plea deal. So a little bit of funky business going on over there. But that trial's actually been pushed back to fall of 2026. So no Shayna Gardner trial this fall. With that being said, yeah, so Kerno Audits says Jim put up an AI filing folder in his Google Drive. Bit of a giggle. He's got his Mook Took slander folder. He's got, did he have a Miles Farley? I think he has a Miles Farley slander folder. And now he's got hot mess AI filings, where attorneys are using AI filings. I think that might have been one of his more recent streams too, right? I think it was this one, but I think he did two. So this is at least one of the recent filings, Jim on AI cases. And he did also look at Joe Tacopina calling out Tyrone Blackburn for using hallucinated case citations as part of his AI deep dive in the stream. So that's in the chat there. Shad Diggy says, FYI, Relly scraped his knuckles by not hitting that like button. Don't let this be you. So hit that like button, you guys. Mookie, good to see you. Hope you've been doing well. Yeah, so Dilbert, it was something like this. Pending assault charge, that's why they held her for 50... I think it was a bond revocation, not probation revocation. Going back to the Florida case with the Target theft. I think this is triggering the recall. I think it was a bond revocation for a pending assault charge. And that's where the 50 days came from. Thank you, Dilbert. What would we do without the chat? Colonel says, yeah, he went through a bit of it in his last stream, I think. I think you might be right. His last stream looks like it's the Julian Conley trial, but I do think he segued. I do think he got off topic. If there's an AI case citation, a hallucinated case being used in some attorney's motion somewhere, Jim's probably gonna segue on a live stream. So love to see it. Guys, what cases are you following or paying attention to right now? You know, obviously it's hard not to see updates on, you know, Karen Reed adjacent cases. We have the Karen Reaves civil case going on. John O'Keefe and the estate of John O'Keefe, they're like suing everybody. Karen Reaves' side has said, well, we expect to bring some litigation towards several other individuals and parties, so expect that to be on the road. We've got some ancillary issues with the county, the prosecutors, because of the Brian Walsh case, Sandra Birchmore. A lot of that is happening now. So if you're looking for something to check out, really Norfolk anything seems to be a hot mess case. If you're looking for the things that will make you sigh and wonder how this is happening, you could probably search any one of those things. I know Melanie Little does a lot of coverage. Potentially Criminal covers the when there's motions, not really so much of the Twitter infighting about any of the cases. Potentially Criminal will go over the motions and the hearings. I haven't seen Andrea Burkhart live to cover any of the new happenings for anything Karen Read related, but she did say she plans to cover the Courtney Clenny trial when that starts in December. So you guys know I love Andrea Burkhart. Her analysis will be amazing, I have no doubt. So that's someone to keep in mind for Courtney Clenny in December, although she hasn't done a live in, I think, like 2 months, 3 months. Who else do we got that's like really like streaming? Broken Baker sometimes still covering that stuff. Young Jerks. Turtle Boy. But I don't know. Are there certain things that he can talk about with his own case? I don't know if he like refrains from talking about his case or not, but I would imagine going to one of the other channels to look at coverage of his case for things that he can't particularly speak on could be an option. But there's tons of stuff there if you guys are looking for something to pay attention to. Where's Tape Is? When's the next thing happening with Mickey Stein's case? Because that's a whole mess. That's a whole mess. And then the next one on my radar, it's not going to redirect to the stream that Dolly Talk is going to be doing at 5 p.m. on the actual case. Dolly's going to be covering the James Ogletree trial, starting with day 1, starting today at 5 p.m. Eastern. But he's live doing a courtroom roulette. So he's hopping around to different proceedings, different judges, watching how the court system goes down. You'll see, hey, it's Luis hanging out over there and some other familiar faces. So if you want to check out when he does go live, actually it says upcoming. So he's not live yet. Let me make sure I link to the right redirect. Yeah, okay, I don't see it. He ended 6 minutes ago. All right, so I'm going to drop the link to day 1 of James Ogletree. All right, so there is that in the chat. Okay, it's not sending. There we go. Tabiz TV says the Steins case has a lot of twists and turns. I've been heavily talking to Taya Adams. Taya Adams, you guys, shared her experience. She did a great interview. I should say Tabiz hosted a great interview with Taya Adams on her channel. On his channel. And he's got a ton of other coverage of the Mickey Steins case. He says he might be heading over to Kentucky. He's going to be boots on the ground. And again, the best thing if you want to see when he does a stream, you've been on a bit of a break. I know you work a lot too, Tabiz. But hit that bell so that way you know when something's happening in the Mickey Steins case. You'll see a notification for his channel there. And then I had to figure out, you guys, I don't know if it's because YouTube sucks when you try to search for people's names that, Flesh of the Gods always brings up a lot of song lyrics, and it's hard to get to Flesh of the Gods channel. But he changed his channel name. So I updated my link in the description for his channel, but he covers a lot of court cases that don't necessarily get as much buzz. He covers big trials too, like YSL, Melly. But really, do you guys remember when 2 months ago, Georgia judge read the wrong verdict? He read the verdict as guilty when the defendant was actually found not guilty. I only saw that clip because I popped over with Trakisha. I think Trakisha popped over too. Flesh of the Gods was covering that live. And we started talking about it like, holy crap, that's crazy. And then it went viral. So he covers a lot of cases that kind of go under the radar, except in moments like that where things just blow. So, so he changed his name to The Source, FOTG. So we're going to have to, I'm going to call him Flesh for a while. I'm sure I'm going to try to make sure I properly describe him and get you guys on the right path. And here is a link not just to his channel, but a clip from the trial that we just talked about. So there's that there. Jimmy Jew says, I'm following a local trial in my town, Jeff Spence, who allegedly killed his son-in-law. Yeah, I was going to say it was a hung jury, right? So it ended in a hung jury today after only 4.5 hours of deliberation. Yep, so I heard about the hung jury in that, and that's rough, right? Family has to go through the trial again. Defendant, I mean, I'm assuming maybe the state will decide otherwise, but the state will argue. We watched, was it Adam Abate argued in a PowerPoint presentation in some Fulton County case, we only get one shot. We only get one shot, jury. This is your only chance to get the bad man, right? When it comes to mistrials due to hung jury, 9 times out of 10, maybe higher than that, it seems like there's always a retrial. I pretty much always. So I imagine there will be a trial too for Jeff Spence. But who knows? And then let's see. Any other cases? And what's going on with Woody? Didn't he get arrested? I mean, I know, I heard he got arrested. I would say if you're involved in anything high profile in Fulton County or surrounding counties, because remember in Georgia, they were going, Fani was going in front of the Senate wanting to increase the power of prosecuting individuals for things that happened in different counties and expand the jurisdiction that a district attorney had. You've got eyes on your back either way, whether you're doing something or you're not. So, and a lot of, if you guys have missed it, Young Thug did one of his charity concerts on the courtroom steps over the weekend. He posted a be there at 4:30 this weekend, and it looked like a huge crowd for a makeshift concert. So that was cool to see. Just right on the courtroom steps, which is just hilarious. It makes me wonder. I didn't think about it when Judge Whitaker made that a term of his sentence, that he has to do these charity benefit, these, public awareness concerts back in Atlanta. He's not allowed to be in Atlanta without permission, but he's got to come back to Atlanta to do these things. And I wonder, since it's a requirement, obviously the sheriff's department was there for security purposes. They were prepared for it. They knew about it in advance. Was it just an idea that Whitaker spit out there and they figured out the logistics later? Or was it kind of a troll move for Whitaker to have a defendant that she chose, it was a non-negotiated plea. So Young Thug's sentence was in Whitaker's hands. Was she like, you want to use lyrics against everybody in this trial that you wasted 2 years of this jury's time and the public's time? Well, we're going to bring these lyrics to the courtroom steps. You've got to come and perform right here, right now, 4 times a year. So, Cash Money Cass says Whitaker was definitely in attendance. Let me get you guys that link. Let's see. I like when I search Cash Money, Cass is the first person that comes up for me. You've taken the top spot on Twitter search for me. But we've got a Judge Whitaker at the courthouse enjoying one of Jeffrey's concerts. So go check this out and make sure if you use X that you follow Cass, because she's great. This is far from the only piece of content she's given us. Keisha says, I didn't really pay attention, but that's funny. Keisha says it looked like the same sheriffs that were in the courtroom. And I remember when they were playing Lifestyle outside the jury's presence, it was like during Motion's argument or something. There was a little head bob. And was it Doug that bobbed his head a little bit? We saw some motion. So good stuff there. So there we go. I think we're going to wrap this one up, you guys. Thanks for coming to hang out on an unplanned stream. Again, covering another crazy case. And who knows about the circumstances, right? Maybe Reaves was following this guy for 40 minutes, knew that the guy in the car had this plan. We're going to drive around, then we're going to shoot this guy. All right, I'm going to get you the gun for it. We're going to do this thing. Maybe all of that happened. But do we want to be able to take lyrics to get us to the conviction? Because this appeals court's holding that without that song and the lyrics in that rap poem that were rapped over the jail call, we don't know. We don't know if they would have gotten there on that second count. So, not a fair trial. Do we want that to be the way? This appeals court doesn't want that to be the way that convictions can be scored. And I'm saying scored for a reason. Again, if you want to check out this filing, I'll drop the link one more time. It's in the description for Replay Crew. And any closing thoughts, you guys? I'm going to pick something to redirect us to. Any closing thoughts, or if you want to shout out where you're going to go over and hang out and watch. This is the filing or decision. Drop it in the chat so you guys can, there's always somebody looking for something to go watch, myself included. So drop your suggestions in the chat, or even something that you recently watched. Let's see. And who do we have right now? Florida, I see alternate corner is live with Florida versus Leslie Dale Boyo. So there's one. Oh, Nick is doing the bond revocation hearing, and it says the hyperbarics case. So there was like a hyperbaric chamber explosion case. It's like crazy stuff. So that's an option. It doesn't tell me back here how long people have been live for, so I can't tell you who's starting early or not. We can go check out the hyperbaric hearing. And then, STS says, thank you again for the stream. It came at exactly the right time for me. You know what? Me too. I know I've been gone. There's been some things that I wanted to pop up and talk about, but I've been so buried in work. I really started to feel like I'm approaching burnout. And I don't want to get to that point. I want to get to that point with work. I don't want to get to that point. I don't want to be on stream and just feel like I'm like forcing myself to talk about something. I want to be on stream because I like I like looking at stuff like this with you guys specifically. And I didn't even have it in me to put together quick videos. So I don't know. And then this time has gone by 2 weeks. It's been really, really enjoyable to hop up and do this today. So right back at you, STS. So I'm glad you feel that way. I feel the same. Like, I think this was needed. And I appreciate you guys so much for, over on X hanging out, or, we make I'll post a community post. And at the end of the post, I'll be like, I miss you guys. And you guys will comment like, we miss you too. So you guys are actually reading like the whole post to see my comments beyond the actual news. So really appreciate you guys a lot. Yeah, Mary says cure for burnout is come spend the day with us. It feels like that. But most of these days, like in the morning, especially, it'll be like, get a phone call as soon as I think maybe I'll do something. Get a phone call. So it's been a bit unavoidable. Although I am blocking off time for Courtney Clenny. Like, walls, do not interrupt me during this time of day. until the Courtney Clenny trial is finally happening and finally done, because we've been waiting 3 years. But always love to spend time with you guys. And no, Trikisha and Sunshine for you. Sunshine's coming in here like, good afternoon, guys. We're getting out of here, but it is good to see you. We've got some eyes for FFS. And then let's see. So I do not yet have a drive with the appeal response or the filing for Quintavis Greer, which that one's still at the trial court level. But I believe those are coming, and we'll go live and we'll talk about them. So there are updates. There are works in progress. You know, the fight continues for Munktunk and now for Quintavis Greer. And a while ago, Jim had said that Quintavis Greer, there's something, he's another one where the plea said you shall not commit no crimes. Like, just nonsensical terms. How do you abide by that? But a while ago, he said that there was even bigger messes than what we've seen with Munktunk's case over in, you know, the additional issues being raised in Munktunk's case. There's more. But then there's also separate and egregious messes over with Quintavis Greer or Unfunk. So definitely want to take a look at that when the time calls for it. And hopefully can do that all with you guys. And it'd be great if Jim can and wants to talk about those things. Yeah, we want to make sure we support his channel. You know, he's doing a lot of his stuff pro bono. So I know he does it for the fire, the passion behind it. But everybody's got to make a living, right? Got to keep the house together. He's got a dog. The dog needs dog food and treats, you know. He's got to get a little something for the work that he's doing. So if he can go live on any of those things or anything at all, we definitely got to make sure we support in all the work that he's doing as well. So with that being said, at the very latest, I will see you guys October 15th. This is a Florida case, so it's East Coast time. That's 9 a.m. Eastern. I should have written that in here. I like to use ET because standard and EDT, EST, not always consistent. I'll just put ET. There should be cameras, so we should be going live right at 9. This is no longer Judge Laura Sharon Cruz. So if you've watched any of the other motions hearings for the Clenny murder case or the Clenny laptop case, the judge that we got to know was Laura Sharon Cruz. But now that we're approaching trial, the trial lawyer is Andrea Wolf Dickerson. Rickerson? I think I'm combining Dick Wolf from Law and Order SVU with Andrea Wolf Rickerson. I think it's Rickerson. But she will be the trial judge, so she will be presiding over these hearings moving forward. So it'll be a new judge, and we'll see what happens. See what happens. Most recently, they filed a motion to dismiss. I requested the file. Haven't gotten it yet because when I praise the quick response I get for anything with Courtney Clenny relating to exhibits, that's me requesting the records from the Miami-Dade State Attorney's Office. And their clerk is super responsive, super quick, like emails me back within like an hour and a half. But when it's a motion, that's county records. And it's not being supplied here. We have a new system here. They updated their system here for Miami-Dade, but they're not uploading the documents for certain things. Like this motion to dismiss wasn't uploaded, and I still have not. They asked for my mailing address. They responded to me, the county clerk, but they haven't actually. It's like every 4 or 5 days I'm getting one response with a new question. So I am trying to get it, but based on a quick article that I saw, it looks like the motion to dismiss is arguments relating back to improper conduct by the state with the violation of attorney-client privilege. And then now an additional issue, you see this notice of deposition here. One of the individuals deposed was, oh wait, this is more recent. Let's see. It's a different one. I think it was this one. Now, deposition you usually hear in like a civil case, but Florida there's a few states that are, and if Freedom Ring is in here, Freedom Ring helped give me extra context on this. I know depositions aren't that common right, in criminal proceedings. But I noticed that Florida saw them more often than not. And Freedom Ring, if you're in here, if you're on replay crew, Freedom Ring let me know that, there's actual statutes, there's legislation that, kind of encourages a court to be more open to giving defendants access to deposition power. It's a lot easier for the state to go and subpoena people. It's a lot easier for the state in a criminal investigation to go and approach people. And because they're from the state, people feel obligated to talk to them, even if they're not under like a court order to do so. These are things that the defendant doesn't always have the same access to, right? So Florida and a few other states give the courts more discretion and almost encourage courts to grant defendants' requests to take depositions from requested witnesses. So in the case of Courtney Clenny, they did this, and a lot of Miami PD, the responding officers, fire department, and one of these, I don't know which one it was, but in one of these depositions, they wanted to speak with, if you guys watched the Courtney Clenny body cam, the first response video, there was a security employee wearing a red shirt. We call him Red Shirt Guy. You saw him propping his foot up in the elevator and holding a phone in his hand, pointing down to where Courtney Clenny is sitting like covered in blood in her bra and robe. And it looks like he's taking video or pictures. Well, defense deposes him. So they get this like interview, they get to ask him questions. It's a lot more open format than in a courtroom on the stand where you can object and stop the witness from answering. And they got some more information volunteered by this security employee in the red shirt that he was told by the state, by the police. Remember, the state, the prosecution, they're all arms of the state. He tells the defense during this deposition, according to the motion to dismiss, that they told him, the police told him, to delete the media. So presumably he was taking pictures or video or both. And he says the state, I don't have it because the state told me to delete it. So the defense is using that in their motion to dismiss. If taken at face value, we believe that the state told me to do that. That's a failure of the police to collect and preserve evidence. And they're acting recklessly by instructing the destruction of it. Now, it could just be that this guy's lying in a deposition, pointing the finger at the police, or the police could have told him to delete that off your phone. Maybe the police said, hey, get that phone out of here, and he misinterpreted that to mean delete something. So I'm sure the state's going to find a way on that particular issue to say the police didn't knowingly do that. That's not what they meant. They didn't give that instruction. So I don't think it'll go all that far, but it was really interesting to see that mention. Again, I am trying to get the full motion so we can just read it. Not having luck. It's taking like 3 weeks. So maybe I'll follow up with them again today. But that's where we are as far as recent developments. I'll drop a link. Let me get a playlist link and then we'll get out of here. If you guys want to, we've covered news coverage, we've covered exhibits, we've covered Clenny's journal notes, we've covered hearings, we've covered the laptop case, tons of stuff on Courtney Clenny, and I've done my best to put it all in a playlist. Playlists. Clenny. Okay. How do I share a playlist link? All right. So here is the Clenny playlist. And the recent stuff is mostly hearings, motions. But if you scroll down a ways, you'll get like video 10 is the elevator footage with Danny. We can pull that up. Let's see. Do I have him right in the thumbnail? It doesn't show on the thumbnail. Let me find it. So this is red shirt guy. This is red shirt guy right here. And there's no sound in this video, I don't think, because this is who we're talking about when it comes to this deposition. So we knew he'd be an integral part of this case. If you want to go right to this elevator footage, here's that link. And again, we'll get caught up in some of the background context. One final cat lore. I did what was going to be a full, comprehensive video, like documentary style, from the beginning notes, using Courtney's journal notes about the beginning of their relationship and some stuff before she even met Christian Obumseli, all the way through to whatever laptop scenario was happening at that time. I think when I recorded it, it was before the judge dismissed the state decided to dismiss the laptop charges after the judge found a violation of attorney-client privilege. It was going to be like 2.5 hours long, maybe a little less if I wanted to do extra trimming. I recorded all the footage. It was in chronological order. All the exhibits were great. It was really, really something I was proud of, because recording something with stuff all over the screen is different than streaming with one screen at a time. Did the whole thing. My mic wasn't recording for any of the footage. So it was like 5 hours of raw recording, just garbage, gone. And I never had the heart to try it again. But we've got it in bits and pieces all throughout this playlist, like everything that you could think of. And we'll do some summaries. We'll get you guys caught up as a refresher, or if you're tuning in for the first time closer to her hearing. Yeah, Aaron. Just no. I was like, please, just like somehow my voice just please appear in this footage. So that was a time. That was a time. And yeah, you can see right up here, April 3rd, 2022. So this has been a long time. With that being said, you guys, this is going to take us over to Nick Starro. He's going to be looking at the hyperbaric chamber explosion case. You know, kind of different subject matter, but sad story still. We'll find out what's happening over there. And no outro song. I need to come up with a channel song to outro us with. Oh, and in my hiatus, I did create a Discord server. There's not much going on right now. I started to do some organization, but it's where I want to be able to post updates on like motions, filings, when people are streaming about a case, if you guys want to share stuff, or if you guys just want to chat when the stream isn't live. I don't plan on having it being some type of like, hey Arnold shrine closet about Cat Not Williams or anything like that. But if you want to use it, if you want to hang out, trying to use Discord more. I've only really ever used it for video gaming. But we'll see how it goes. And even if you guys want to connect with each other and hang out with each other, that is absolutely fine by me. It's called The Chat. So there you go. I think that's the last thing, you guys. So let's get over to Nick, or wherever you guys are going. See you guys on April 15th. Again, that's Wednesday. That's going to be early in the morning, East Coast time, 9 a.m. Eastern, for Courtney Clenny. So maybe earlier for something else, but who knows? All right, bye, you guys. See you next time.